Honourable Member for Nelson.
Thank you, Mr. President. I was going to provide an outline of some concerns relating to the core principles of comity between the chambers. So, Mr. President, the core principles of comity can be summarised as underpinning the following things: equal status, mutual respect between the two houses, providing independence and institutional balance. Secondly, working relationship, that's to ensure communication between the houses is open, such as refraining from insulting language or reflecting upon the other house or its members. And the third one is non-interference, so neither house interfering in the internal proceedings, privilege arrangements or daily operations of the other. Clearly, Mr. President, the failure of the government to respect and respond to a resolution passed by the chamber is an affront to that paramount comity principle of mutual respect between the two houses, independence and institutional balance. And by balance, I mean the fact that one chamber is not subordinate to or have lesser scope and powers than the other, excluding the previously acknowledged financial bills limitation. And crucially, as previously stated, the executive is subordinate to the parliament. Before I move on, Mr. President, I do wish to address a potential furphy relating to that distinction between the executive and the parliament, which may be raised by the government in an attempt to justify its failure to comply with last year's resolution. There may be an attempt to put the spurious argument that somehow this House exceeded its authority or was not in compliance with these comity principles, calling for the actions contained in the 2025 resolution. But to be clear, that 2025 motion did not seek to call on the other place to do anything. If this place had passed such a request, then it would be up to the other place to formally consider, accept or reject such a request. But instead, the December resolution, as does the current motion before us, clearly directs the respective requests to the government, which is to say the executive. In Westminster Parliaments, the comity principle of mutual respect, independence and institutional balance is between the two houses, not between the Parliament and the executive. Yes, of course, we would want a respectful and open communication channel, of course, to exist between the Parliament and the executive, but that is not a matter of comity as it is between the two houses. As per Professor Richard Herr's testimony on the 6th of September 2019 before this Council's Select Committee inquiry on production of documents, of which I was a member, and I quote this from Professor Richard Herr: "The supremacy of the Parliament requires that the government accept its position of being responsible to you, not telling you what it's going to allow you to do to be able to do your job." And further, Mr. President, he said, "Parliament is the enabler of the government. The government doesn't exist if you don't pass laws. The government does not exist if you don't pass money bills. You are the enablers. They are the supplicants to you. You are not supplicants to them." End of quote. So the failure by the government, the executive, to formally respond within 6 months as per the resolution of this place is a disappointing and unacceptable example of this chamber yet again being treated with contempt. It is arrogant, dismissive and, to put it bluntly, Mr. President, undemocratic. It's an attempt to snub the principle of comity between the chambers. We have examples of the executive acting on non-government motions moved in the other place, but not those passed by this chamber. The cynic in me thinks the prioritisation of equivalent non-government and crossbench private members' business of the other place over private members' initiated resolutions of this place is due to the ramifications of successful censure or non-confidence motions passed by the Assembly. However, a truly accountable government of the day, respectful of the parliamentary foundations and conventions in which we operate, would act respectfully on resolutions passed by either chamber without requiring potential standoffs over censure motions. So, Mr. President, earlier I stated the lack of government action on the December resolution as an example of a vote of this chamber being treated with contempt by this government yet again. As some members will recall, and for the benefit of new members, it took 3 votes in this chamber to secure government action on ministerial diary disclosure reforms. In March 2023, this chamber passed my motion calling for public consultation on developing a best practice legislative ministerial diary disclosure scheme, including more timely release of diaries and more detailed content to be provided. Instead, the Rockcliffe government announced it would move to quarterly disclosures, but left it unlegislated, hence voluntary and without any public input or form of consultation. Subsequently, on the 10th of September 2024, this chamber again voted for my second motion of the ministerial diary disclosure system to be put out for public consultation regarding its adequacy and requesting the government report back on progress by 28 November 2024. I know we all here will be surprised and shocked by the fact that the date passed without the government acting upon that formal resolution of this place. So again, a year later, on the 23rd of September, this place passed another resolution calling on the Rockcliffe Government to establish a public consultation process on best practice ministerial diary disclosure models and require the government to provide a progress report by 5 December 2025. Finally then, in response to that, on the 10th of November that year, the government released its discussion paper on that topic. Now is not the time to go into the strengths and weaknesses of that eventual reforms progressed by the government. The point I'm making in recounting this example is that, shamefully, it does not appear the Rockcliffe Government has changed its stripes when it comes to failing to respect resolutions of this place and dragging its feet in appropriately responding to those resolutions. There is no good excuse or justification for the disrespect shown to this chamber by this government. The Council's resolution on gambling advertising in December last year did not demand sensitive or commercial in confidence documents. It did not demand privileged Solicitor General or other legal advice provided to the government. What this chamber did ask for was for the government to stand up for Tasmanians, particularly our young people and those vulnerable to being preyed upon by predatory and destructive gambling entities, when the community should just be able to enjoy watching, attending a sports game and cheering on their local teams. Also pertinent in this context, Mr President, to remind members of the statement presented in this place by the Leader on Wednesday the 24th of June this year to address concerns raised in this place regarding the attitude of the government to the Legislative Council. We were assured on that day that, and I quote, "The Premier and his government look forward to continuing to work constructively with all members of this chamber." And, Mr President, that commitment was in relation to both adjournment matters conventions and also, and I quote again, the range of other pathways available to raise matters with the Executive. So, Mr President, in the context of the Council's December resolution, here was the Premier's opportunity to demonstrate that reiterated intent of constructive good faith. How are we meant to interpret that reassurance of barely 2 months ago now, Mr President? Will be treated with good faith when it's convenient, it would appear, and ignored when it's inconvenient, perhaps. That is not how it should work, Mr President, and shame on any leader, let alone a Premier, to think that it would be. This chamber is not being treated consistently with the respect it should be afforded in accordance with the principles of comity between the Houses and in respect of the Tasmanians we in this place were elected to represent. Mr President, there's another faux argument which I wish to preempt and hopefully by doing so prevent too much of this chamber's time being wasted on a red herring. As members would be aware, nationally there has been mounting pressure on the federal Albanese government to implement in full its stated acceptance of the 31 recommendations from the Murphy report. So I could well imagine there'll be some within government trying to excuse its inaction along the lines of, well, the Albanese government is going to implement the gambling in stadia ban anyway, so there's no need for Tasmania to do so, and there's no need for us to table an update in the state parliament. Well, Mr President, wrong. Recommendation 26 of the Murphy report acknowledges the roles of states and territories in the implementation of this particular recommendation and the need for the federal government to consult with those other jurisdictions. And further, I reject the notion that Tasmania cannot be a national leader in this space. In fact, this chamber's December resolution itself thrust Tasmania upon the national leader's stage in the matter of disrupting the social norm that betting and sport go together. The full compliance with Clause 5 of that December resolution requires a statewide ban to be implemented, both on gambling advertising in stadia and venues and on team uniforms. And as acknowledged by Clause 3 of the current motion before us, we know that should the federal government reforms pass the Australian Parliament, the best case scenario will not see those reforms commence until 2027. And further, nothing prevents the state taking action, immediate action, within their own jurisdictions. There's nothing to prevent that, nothing standing in our way. In fact, there's no good reason for the Rockcliffe government to stall the proposed state ban. Now the federal government has acknowledged the public harm currently being caused and the need to remove gambling advertising from sporting venues and gambling branding from players' uniforms. It will send a strong message regarding the government prioritising the community's welfare over corporate interest. It will be preventative, consistent with the government's stated public health policy, and it would also reduce the opportunity for gambling corporates to attempt a pre-federal ban rush, which we have seen in other areas of public policy reform. where affected vested interests attempt to buy in this instance seek to install gambling advertising or lock in sponsorship prior to a change in government policy coming into force, either in a strategic attempt to slow down those reforms and or to set up spurious compensation claims, for example. But Mr President, the current motion before us is very moderate in my opinion. I've already addressed the ramifications of Clause 5 of the motion before us, noting the seriousness of the failure of the state government to acknowledge or address this chamber's December resolution. It is worth noting that while this motion may serve a rebuke to the government, and not without justification, it does not seek to censor. Instead, it provides the government with a second chance. Clause 6 of the motion today provides a revised timeframe by which the intent of the original resolution passed by the chamber last year can still be honoured and implemented. This motion provides an extension until Thursday, 10th of September, for the government to prepare and return to this chamber the currently outstanding response to the 2nd of December resolution, and which is to also address both the call for the gambling ad ban in state-owned venues and on players' uniforms, while also providing an implementation timeframe update. By doing so, this motion presents a second chance for this government to demonstrate that it is prepared to put the welfare of Tasmanians before gambling and betting interests, at least in some small but significant way. It also provides a second chance for the Premier to demonstrate he is committed to the statement delivered by the Leader on the Premier's behalf to this chamber on Wednesday the 24th of June. Further, that his government does and will continue to respect this chamber, its role within our bicameral Westminster Parliament and the principles of comity between the houses, in action as well as in words. I hope to hear an apology when the government's response is delivered today, not to me personally, of course, but to this chamber, for such unacceptable disrespect and breach of the principles of comity between the houses, and to those Tasmanians who welcomed this chamber's resolution of 2nd December 2025 and expected in good faith for this requested action to occur. In closing, Mr President, we should not need to have had this debate here today. It's very disappointing that due to either the inaction or disrespect shown by this government towards a resolution passed by this chamber, we have had to take up our time again to seek an explanation as well as prompt compliance. As I stated at the outset, the intent of this motion today is not to re-prosecute the substantive matter detailed in the initial motion debate of 2nd of December last year. Instead, the purpose of today's debate is to, firstly, place on the public record the failure of the government to comply with an agreed resolution of this democratically elected chamber. Secondly, to provide a formal opportunity for the government to address the outstanding deadline for the 6-month progress report on the 12-month deadline to establish a formal policy ban as per the resolution passed on the 2nd of December 2025. And thirdly, to reiterate the democratic expectation that resolutions passed by this chamber will be respected by the government of the day and acted on accordingly. And further, Mr President, to that, to respectfully require that the government places a formal response before this chamber by the revised date of the 10th of September, detailing the implementation. Legislative Council resolved last year Tasmania should do its bit on the public policy matter of addressing the negative impact of gambling ads and sponsorship in local sport. That resolution should have been respected, acknowledged and acted upon in some way by the government, no matter its policy position on that matter. Hypothetically, the 6-month report could have simply stated that correspondence from the relevant minister or department had been sent to all state-owned or funded venues advising them of the council's resolution, that the state has requested an update from its federal counterparts regarding the implementation of the Murphy report relevant recommendations, but there is nothing further to report yet. For example, I would have considered that satisfactory, to be honest. I wouldn't have considered that satisfactory, to be honest, but at least it would have demonstrated an acknowledgement of the Council's resolution, which required a formal and appropriate response by the 6-month deadline. There have been opportunities between when I tabled this motion in June and now for the government to provide the requested update, which would have saved us time here in the chamber, as well as avoided the unnecessary and concerning compounding of this government's reputation for arrogant disrespect for this chamber and for the broader parliament. It's now incumbent, Mr President, upon the government that in its response to this debate here today, it must either include the required 6-month implementation plan update as per last year's resolution, or at the very least commit to table that update by the 10th of September as per clause 6 of this motion. So on that, Mr President, I commend the motion to the House.
The question is the motion be agreed to.